is titled Issues in Corporate Data Privacy. And we're going to change the focus of the conference here quite a bit. We heard a lot in the morning about data privacy from the perspective of the consumer and how the consumer can attempt to regulate how his or her private information is being used by businesses and governments. For the afternoon panel, by and large, we're going to shift focus and take a look at data privacy from the perspective of the corporation or business. And in addition, in the two morning panels, we heard a lot about what data privacy laws should be and the way that data privacy laws need to be changed in order to protect things. But largely for this afternoon, we're going to be dealing with data privacy laws that we do have on the books. Because of many of the concerns that were identified in the morning sessions, we have had a lot of legislative activity at the state and national level and internationally in other countries as well that does attempt to regulate how businesses deal with the private information of consumers. And as a result, we have a large number of laws that deal with how private information is used and retained, or must be retained, or cannot be retained. And there are a lot of laws in the books. And the question that we pose to this afternoon's panel is, how does the responsible business deal with complying with all of the existing laws that are on the books? And we have a very distinguished set of panelists to help deal with this question. Starting on my left is Michelle Finneran-Dennedy, who's the Chief Privacy Officer for Sun's Microsystems and founded Sun's Privacy Council. She has a bachelor's degree from Ohio State and her JD from Fordham University. Next to Michelle is Peter Cullen, who is the Chief Privacy Strategist of Microsoft, which is a corporation that should be familiar to most of us. And he has an MBA from the Richard Ivey School of Business at the University of Western Ontario. In the middle, we do have a consumer representative here, Tien from the Electronic Frontier Foundation, who will be here to hopefully remind our panels of some of the consumer protection interests that were raised this morning. On the other side of Lee, we have two attorneys in private practice who deal with these issues. Michael Blum is an associate with the Intellectual Property Group of Fenwick and West here in Silicon Valley. And he has his bachelor's degree from the University of Michigan and his JD from Stanford Law School. And with Michael is Maureen Young, who is a partner at Bingham McCutchen in the Privacy and Security Group, as well as the Financial Institutions Corporate and Regulatory Group of Bingham McCutchen in San Francisco. And before joining Bingham, she was Assistant General Counsel at Bank of America's Legal Department. So, in order to have our panelists address these issues, the first thing I want to start with is, okay, let's assume that we're representing a typical internet retailing business. An internet retailer that advertises goods for sale on the internet. Customer can select that good for purchase and order it online to be mailed to his or her home. And obviously, in order to complete that transaction, the company has to collect certain private information about its customers. What type of information is that company collecting? What are they doing with that? Are they retaining that information or discarding it? If they're retaining it, what should their retention policy be? Retaining it for how long and for what purposes? What are they doing with the information? What should their data mining policies be? What should their policies be about sharing that information with third parties? And in particular, what legal obligations does the company have to inform customers as to what it's retaining or doing with this information? What legal obligations does the company have to refrain from certain practices? So we want to keep this on a pretty practical level, right? Again, the focus of this afternoon session is how does a responsible company go about complying with the various laws that are in place? So let me start by passing the baton to Michelle and asking her to respond to this question. And let's start with sort of what are the privacy policies that are in place on the state level in California.
Is it still?
Oh, no? Style. How about that? There we go.
Michelle's always likes to have a mic.
Don't start with me, Peter. So it's interesting because when I hear the hypothetical, and we didn't hear the hypotheticals in advance, so this is on the fly stuff. I would never start the analysis of how to comply with California, quite honestly. Our company in particular, we do business in over 100 different nations around the globe. So when you're talking about e-commerce, unless it's going to be a very localized program, you're not talking about starting with California. Now that said, certain things like, see, I saw Joe McNabb earlier. This is now her office is coming to take me away for not prioritizing them first. California is obviously in the mix, so when you talk about the data retention, for example, you have to think about the type of information that is appropriate to collect for that type of campaign. Is it going to be implicated under a peace bill type of security breach notification, for example? So looking at the character, the localization issues, what the business will do with the data, because the data is an asset to the business as well as something that is owned by the consumer. All of these things are the first assessment I make before I ever dig into a single statute. I don't want to hog the mic.
We'll come back to you, but let me pass the question to Peter.
Let me just add on a little bit further, because I think Michelle's made a great point in terms of thinking about California vis-a-vis the rest of the world. The place that I think companies are now starting to begin with is what are the customer's expectations? Because in many cases, irrespective of the level of the law of the land, the customer has a much higher expectation about how their data will be both used and protected. The retention aspect of it gets a little bit more complicated. We can think about many of the questions that were proposed in the hypothetical can be effectively handled by transparency, by notice, by choice to the user. It becomes more complicated when you start to manage your obligations that you may have made to the consumer as part of that notice. Where retention gets a little bit interesting is that one can think about it, well, of course, the data would no longer be required the minute the consumer finished with that transaction or finished with that service. But that's not necessarily what the consumer ultimately needs. Think about it in terms of a financial services organization. If the financial service organization got rid of all of that customer's data at the end of the relationship, that would make it very difficult for the consumer to be able to come back perhaps a year later for either a legal matter or tax purpose to get information that they may have provided about their transactions. So it's just not quite as simple to say that. So organizations need to think about everything from use to retention and provide that up front to the user in our view in a very clear and transparent way.
Let me ask the same question of Lee, but with a slightly different focus, because I know that you wanted to talk about a particular type of information that is collected and retained that is different from what we ordinarily think of as personal private information.
Well, let me start by saying that there are easy questions and hard questions in this area, and I think that it's actually maybe useful to think in terms of some of what I would at least consider to be an easy question. I think what Tyler asked, for instance, about, okay, so name and address in order to deliver you, but no one would question that you need that for the duration of the transaction. And then you might say, well, if you're constantly transacting, as I think Daniel Solo was saying, about 800 books from Amazon or something, you might really value their knowing where to ship those books over time and be willing to establish a relationship with them. On the other hand, let's take the by now infamous Google example. Google is apparently logging search histories so that they have in some form IP addresses that are linked to the actual queries, and clearly they need to know the IP address in order to return you results at the time. But once they have returned you those results, do they need to keep both the information about what you search for linked in some fashion to the IP address of your host. But certainly it's not like requiring you to, say, as a consumer, undergo the inconvenience of having to type in the address again or anything else. That's all taken care of already by your browser, right? So is there any reason for them to retain, that kind of information? So I think that a lot of the things we're talking about, when we think about this, we can identify easy places where we can say, well, anything they're doing with that data, storing it beyond that transaction, clearly isn't for the real benefit of the consumer. It's for some other benefit, and it's easier to separate that out than I think in the hypothetical case. Then the second thing is that you're aggregating a lot of interest. You can be aggregating a lot of interest in history information over time in cases which I think are different for a couple of reasons. One, when you're buying, say, books from, if you're buying something from an online retailer, this is really pretty much about you and that company. Contrast that with, say, telephone company records or records of where your emails are going. Now it's not just about you and the company. This company is actually tracking things that are about you and other people in their relationship. So that's the first big difference, right? This is keeping data that isn't atomistically individualized. It's really about with-type relationships. And that, just you extend that out just a couple of degrees of sort of separation, as you will, and you see there's an enormous amount of territory that's covered there that isn't really present in the simple purchase kind of example. And then, of course, because it is communicative, we generally in the law think that there's some extra bit of sensitivity to that than there would be for something that is not a communication transaction. So I'll stop here and pass the baton.
Okay, and let me ask Michael again. If we can, think of the typical internet retailer. What, if you were advising an internet retailer, what privacy protections do they need to be concerned about? What are the current laws that are in place that govern what they can and can't do with that information?
Well, what's interesting about that, and what's interesting, I think, about my perspective, and probably Maureen's too, is different from probably anyone who's spoken so far today, is that different clients, different internet retailers, are going to have a different take on this kind of question, and they're going to each perform their own risk assessment about what sort of consumer protections they should take on. And what's really interesting about it, and I agree with Michelle, if you're coming at it from just the legal perspective, you probably start assuming they're not just a local company and they're an internet retailer, right? So they're probably international. You start with international laws if you're coming at it from just a legal perspective. But when most of my clients are doing this risk analysis, their view of the law is, the law in the biggest sense is, when I act, what will the repercussions be? That's the kind of information they want. That's the kind of guidance they want. And in fact, the largest repercussions in most of the privacy sphere from their perspective, because let me say that a lot of the international laws on privacy are not very thoroughly enforced right now. The biggest repercussions are PR repercussions. So often when I start advising the client on what privacy considerations they should have for their internet retailing business, we start by talking about what's a consumer going to expect and what's going to cause you a public relations problem when something goes wrong.
Let me ask Maureen a question with a slightly different spin, because I know that your experience is you have experience in banking, right? And so because we have financial security involved in banking and financial information, the level of privacy that the ordinary consumer expects is probably higher than it might be for the internet retailer, other than the credit card information, which obviously flows through the bank. So what extra what extra privacy precautions need to be taken in the financial security, from the financial security end?
Well, first of all, and just in terms of the statutory and regulatory overlay, if you meet the definition of a financial institution on Graham-Leach-Bliley, you're already subject to a higher level of standard in terms of your information and security and privacy practices, and you're going to be regularly examined for them. But you also have, as Lee pointed out, a different sort of relationship based on the sort of trust or the expectation that the customer has with its financial institution. And privacy and security remains the hottest issue among financial institutions today, and particularly because breach of confidential information has mostly been directed at breach of financial information, where a naughty actor could actually do something with the information it had in hand. So phishing and spoofing and all sorts of other online frauds are very serious in the financial institutions. We're coming to a point, both in the financial institution sector, and it's rolling out to other sectors as well, where the sorts of privacy and security standards that were okay the last 5 years since Graham-Leach-Bliley was adopted have really changed. And with the rollout of the interagency banking regulations about multi-factor authentication and the deadline for institutions to pony up by December 2006, we're suddenly going to see a lot more serious investigation and investment by financial institutions in trying to further secure their online transactions. So no longer is, for most types of online transactions, a user ID and password going to be enough. And that's very much the norm in the rest of the e-commerce world. Now you're going to have to find some other devices that fit your business model, fit the sorts of services you're sending and the clients you're dealing with, that's going to produce additional layers of checking, authenticating who you're doing business with. And an example of that is Bank of America had rolled out an investment with the Passmark security company, where now on top of user ID, you're presented with a key that you've selected that's unique to you. So if it's a flower, the flower, the rose, when Maureen goes online. But it also comes with a cookie checking to see, is that Maureen in her office in San Francisco, or Maureen in her home in Mill Valley, or, oh my goodness, it's Maureen in Singapore. What is she doing tying in from there? And then they're supposed to go another layer further and call Maureen on her cell phone that she's set up ahead of time and say, Maureen, are you in Singapore today? Did you just dial in? Yes or no? So this push that's starting in the most heavily regulated industry will have impact on all other sorts of internet dealers and will eventually wind up with FTC guidance and with federal legislation, because it tends to roll down in that direction. So I think it's going to be a very interesting this year to see first what the biggest financial institutions do in terms of their selections of technology, and then secondly, what the regulators do next year in terms of slamming institutions if they fail to respond adequately.
And can you remind us what's the significance of the December 2006 deadline?
That's the deadline for having done your risk-based evaluation of your online services and your other security that collects confidential information, for determining what level of multi-factor authentication is sufficient for your operations. And again, they've kind of stepped out here, the agencies, and being open-ended. They don't want to say that for all accounts, user ID and password isn't enough. They want you to sit down and have analyzed, why is it the case that if you're going to wind up with only user ID and password, you better justify it based on the level of risk. And the way the directives have been laid out is it's been after 2 years of intensive reporting on phishing and spoofing and other types of online scams, setting the grounds for saying, look, we're telling you this no longer is enough, and now we're leaving it to you to figure out what you want to invest in, but you better come up with some answers.
Okay, well, let me come back to my internet retailer then, who will be having dealings with your bank on a periodic basis. So far I've been advised of a couple of things. One is that I can't just consider California because as an internet retailer, I'm going to be selling to people certainly across the United States, and very likely I'll be selling to people in other parts of the world as well. And the other thing is that my principal problem may not be necessarily compliance with the laws as it is a PR problem. Okay. So given those two factors, I'm asking you as my outside counsel, as it were, I don't have an in-house legal department yet, but I have to come up with some sort of privacy policy, right, as to what kind of disclosure I'm going to make to consumers about what I plan to do with their information. So how would you advise me in terms of what I should be, in terms of what I want to do, and how I need to advise consumers about that?
So we look first to what the industry is, versus heavily regulated versus not, and we're going to make an assumption that it's not heavily regulated, but it's a general type of retail industry. Then we look to the types of products that they're selling and the types of information that they have to collect in order to sell those products. And we look towards the sorts of relationship they want to maintain with the consumer. Now, if we figure that the retailer is, for example, ladies' clothing, ladies' fashion apparel, and the information that they're going to collect from their customers to cut the deal for whatever they're selling up online would be basically name, address, credit card information, and what they purchased. Out of the box, we know that they have to disclose that you're going to be collecting that information, and they have to decide then how long they're going to store it and for what purposes. Most online retailers will decide that because they want the sort of relationship where the consumer is going to come back with frequency, and they want to make it as easy as possible, that they're going to have the consumer set up, quote-unquote, an account. And with setting up an account then, they're making the disclosure in the privacy policy that this information is going to be stored and will pop up when you come in onto the site. The other thing that you'll often see in the retail area is an interest to follow the consumer's shopping preferences. And what's the purpose of following the consumer's shopping preferences? I mean, you know that you want to sell them more goods. So if you know that they, go to pants or shoes on a regular basis, and they have a particular interest in a certain type of shoe, that the next time they log in, that you're going to pop up on the side of the site their preferences on new shoes of this category that they might be interested in. And because that would probably be their objective of trying to get a deeper relationship with the consumer, their privacy policy is going to have to support the disclosure of the way they use cookies and the way they track information about your shopping preferences and how far the information goes. These days in the internet business, very few retailers that are of any size share information with third parties. And there's all sorts of restrictions if you're a highly regulated entity about being able to do that. But for the most part, most institutions, for fear of how customers are going to react to that, will stake out a position on their site reflected in their policy that they may be collecting information about your shopping preferences, but they will not disclose personal information specifically about you to that third party. Unless then you want to opt in or opt out to having that information being collected. And most retailers, as part of your account line, will have a little box that says, would you like to receive promotional materials from us and from our third-party partners about products and services we think would be of interest to you. And the standard in the industry is that, because most people don't read these things so closely, and they mostly won't change the functions on the site, is not to have the consumer choose yes or no, but to leave the mark check to say, yes, I would like to receive, and leave it to the consumer to decide on a basis if they want to uncheck that to receive or not. So if the consumer has not opted out of sharing, they might share with partners, and they might get referral fees for having information, being sent to the consumer directly from the home. A lot of companies will not share at all, will not partner in that fashion, largely because they're concerned about the PR aspect of it. And what they'll do instead is say, I'm going to partner up with 5 other companies, and provided you didn't opt out on the box on the account that said you wanted to receive other things that we think are of interest to you, we're going to send you emails or flyers or brochures on behalf of ourselves and on behalf of our other companies that we've got referral arrangements with. And there, the idea there is that they've made a stake to say, we won't actually disclose the name and address to these other third parties, but we are still going to market and market with partners, but we'll continue to hold the database of information. And that usually is a preferred position for companies to take because consumers are so sensitive about having their personal information shared with a third party.
Let me ask Michael, if we can. You said one of the things we have to be concerned about is PR problems. Mm-hmm. What are the PR problems that you and your clients are concerned about happening, and how do you adopt policies that try to minimize those?
Well, let me share a really interesting one that feeds off of the situation that Maureen just described, because it's true. I think that the way that you sort of set the basic tolerance for a new company is about right. And there's this concern about the PR risk. And this is a specific problem that I think is really interesting here. Often the stance is taken as described, which is, okay, we'll market our own stuff to you, but we won't share it with any third parties. So you see that all the time. We're seeing a second generation negative effect of that right now, and that's in the M&A, the mergers and acquisitions context. Clients who took that position, young internet startups, right, maybe weren't thinking so much about exit strategy, but in these days of fewer IPOs, the exit strategy is often that they're purchased by a larger company. And one of the reasons that the larger company wants to buy this internet startup is for its great database of customer information. So I'm seeing repeatedly decisions made by companies really that you would think not just care about privacy, but stake their public persona on being a privacy-oriented and consumer care company, saying, you know what, in this, we said we wouldn't share information, but we weren't really thinking about when we were going to be bought, and I don't think the customers will really mind if at this point when we're selling our whole entity, we sell all their information with it. And you know what, customers, in my experience, haven't minded. So I'm going to tie this in with two things from earlier panels. One, what Scott from NBC was saying, which is that people aren't paying attention. It's true. And what was the other one? Tip of my tongue.
Well, it shows, though, back to the professor's question about what you need to have in your privacy policy out of the box, is that you would have this paragraph, if you've taken the line in the sand that you don't share customer information with third parties, you would have it say, we don't share customer information with third parties for marketing purposes. However, we might share for other reasons, including for servicing your transaction, for following through on initiatives that you've asked us to do for you, in cases where we've gone bankrupt or we're going to be acquired in a mergers or acquisition or sale. And you have this whole laundry list, which is consistent with Graham-Leach-Bliley and the other sorts of typical regulations that says that these are acceptable exceptions to when you could share with a third party.
So what's really interesting about that is that the third party could have a totally different privacy policy. And if you take a look at, I don't know who saw Google's new privacy policy they posted maybe 3 months ago or something. They say a lot of things about how they're going to be pretty careful with your information, but they also say, like Maureen's saying, in case there's some sort of sell-off where we sell the division that's got your info, we'll post on our website that we did that, and then your information will be subject to their privacy policy, whatever it might be. So in other words, it's kind of a privacy policy that's really no privacy policy with a hole that big that you could drive a truck through it. I remembered my other point too, which is this ties into something from before too. There was a comment from one of the panelists about certification organizations that don't really require any real protection of privacy to be certified because the way that these organizations get incentives, which is they need customers, and the customers are corporations, and corporations want to sign up with a certification organization that is pretty lenient. So I was in an interesting merger situation where, and this was actually how I learned the hard way that these organizations are so lenient. I was in an interesting merger situation where the client that was a pretty privacy-oriented client wanted to sell a division to another company actually that holds themselves out as being pretty privacy-oriented. And the client's privacy policy said we're not going to share information with third parties. They didn't have this exception for in case of a corporate transaction. And so the compromise that we struck with the acquiring parties council was, as long as the sharing is done in a method that's approved by trustees, which is one of the certification organizations, then we'll go with it. And opt out, and we haven't focused on this much, though one presentation did touch on it. Opt in and opt out they seem so similar, but they're hugely different, right? And opt out is sufficient for trustees. So what trustees said was, go ahead and transfer all the consumer's information against the literal terms of the privacy policy, where you said you wouldn't share that information, and give them 30 days to opt out of the transfer. Just contact them by email and tell them they've got 30 days to opt out and keep a list.
Okay, now both Peter and Michelle represent, shall we say, much larger companies than your typical internet retailer, and somewhat different businesses as well, although certainly deliver some software over the internet perhaps, not sort of what we think of as a traditional retailer, and of course Sun has a lot of hardware as well that's being delivered. So from your perspective, representing a large company with a large in-house privacy group, if you will, or privacy council, how do you go about complying with the various laws that apply to what you can do with data nationally and internationally?
Let me answer the question simply, but then come back to let me put on the role of the CPO for this small little retail company and provide maybe some feedback to outside counsel in terms of what my needs might be. The way that, and I think I speak for Michelle on this thing, the way that larger companies, particularly global ones, have approached this is that we're more concerned about what the highest global legal standard is, and that's what we would set our global policy. So, for example, if you take the United States, where many parts of our business, our customers, are not subject to any formal privacy regulation, we have a global policy that would extend the same European-style privacy protection to those customers, irrespective of the lack of the law. And I think this gets to, we believe that's what our customers expect, irrespective of what the law says. But let me come back to the small retailer and presumably the question that might be posed to you in terms of what additional advice might you give your clients. Because I think what Maureen did was a great job of articulating what needs to be in the policy, but at the end of the day, writing the policy is the easy part. It's ensuring that the company has the facilities and processes and practices to make sure they live up to their policy. And that is really the tough part. And as we've seen with a couple of recent FTC cases, when you commit to protecting the security of your customers' information, the expectation is that you're able to live up to that. And I think we also talked about public relations fiascos, but as we saw yesterday with our dear friends at ChoicePoint, there's some monetary considerations about that to the tune of about $50 million. And that's, of course, before you've actually discounted their stock by about 25%. So there are some significant other implications in terms of not just meeting the law, meeting your customers' expectations, and then more importantly, putting those into practice. So I think the council's role needs to be, in addition to advising on the policy, advising on what type of disclosure might be required, but doing their best to help the organization make sure that it's thought about the policies. Now, if we get back to this hypothetical example where it's a small retailer, let's remember the reason that you were hired as outside counsel was they don't have inside counsel. Probably also means they don't have a chief privacy officer, perhaps means they do not have a chief information security officer, perhaps means they don't have somebody managing administration of their IT. This becomes a fairly daunting problem, so some real value-added advice you can do is to help them think about how they're going to make sure they meet the commitment of that policy.
I'll definitely add on and here. Customer comes first, and particularly if you are in the online world, you have to think highest watermark possible when you're talking about the compliance. But compliance is can do, and I think governance is will do. And so again, meeting those customer expectations are very important. And how you functionalize that is absolutely the key. The privacy policy is 3-4 pages, but behind that are all of the procedures, and it's smaller for your retail company, but again, when you're first collecting the data and you think about who you are as an organization, if I'm this small retailer, you should be thinking of your exit strategy before you get the first VC dime in your pocket to go live. And if you do have such a restrictive promise that you've made in a very clear and conspicuous fashion, a la the FTC, you better think about how are you going to merge with the company if that's your exit strategy rather than going public. In the alternative, when you're getting ready and you're getting larger, you may want to do some sort of a PR customer education to say, we think that Saks Fifth Avenue or Nordstrom or whomever wants to acquire us, and then give real choice to your customer. So if you're going to be very restrictive up front, from a legal compliance perspective, be ready to lose some customers, be ready to dump some data, and be perhaps a small bit less attractive as an acquisition target, but it will make the acquisition go a lot faster. We've actually been through a lot of this in a more complex fashion than just getting customer data, because when you're buying a company, you're also getting employee data. So you need to consider that as well. But the state of kind of maturity, even for a small retailer, is an important part of pricing of the M&A transaction as well. And again, I think if you're constantly leading with your customer needs, the law is a lot easier to comply with.
Let me ask Lee to comment on a couple of things. One is that what I'm hearing from a lot of the panel is that sort of as far as compliance with U.S. law goes, a lot of what's happening is as long as I disclose what I'm doing with the data to the customer, I am okay. And so I want to ask you is, from the consumer perspective, not normatively, but with regard to the laws that are already on the books, do you foresee our internet retailer having any problems with current law? Are there certain things that they simply cannot do even if they do disclose? And what advantages does the European model of data privacy provide over what the U.S. is currently doing right now?
I think that, as everyone here probably knows, U.S. privacy law is very sort of industry-specific, very sectoral. Certainly if you are, say, a retailer who's in the video business, right, you're going to be subject to the provisions of the Video Privacy Protection Act in a way that someone who is selling books is not. But sort of leaving aside any specific laws that regulate an industry like financial services or a video rental or something like that. I mean, the general rule is there isn't much of a rule about what can be kept, how that's going to be handled. It is going to be tied, as Peter was saying, to what promises, what warranties, what kinds of statements you make about it are. So that what we have is really a very strong incentive on the part of retailers to use what we would call weasel words in their privacy policies that essentially give the impression of setting forth some kinds of meaningful privacy standards, and they may in fact even be, aspirational as far as the company's actual practices and intentions are, but at the same time contain enough vaguenesses so that if something comes to the attention of, say, the FTC, which is really, as Peter mentioned, for many purposes, sort of the main, along with State Attorney General, sort of the main kind of club here, where they will be saying, this is unlawful and deceptive because you promised to do X but you didn't. The incentives really are to not make promises. So you would like to have a privacy policy that kind of says,
those wouldn't be outside council-generated weasel words, now would they?
We actually had I don't know if we ever did this. We took some, a selection of privacy policies and mocked them up with little weasels in the different parts, but I don't think we actually put that up on our website. So there is this problem with the way the U.S. law looks at it, and then you have, on the other hand, the EU model, which does have many, many more specific kind of regulations as far as how data processors are supposed to behave. But I think that, and I'm not an expert on the EU law, but the people that I know who seem to know a lot about it are not all that impressed with the way it works out in practice, because it's very, very hard to keep track of what companies are doing. I mean, I think Professor Neff said it much earlier, that one of the problems in this entire area is that much of what a consumer or an individual might be concerned about is behavior that occurs sort of in, behind the scenes. You do not have a direct knowledge of it. You cannot, it is not easy to see how the feedback model that we sort of rely on in other areas of the law works, right? You buy a car and it doesn't work. You can go to the dealer and you say, look, you sold me a crappy car. If a retailer goes ahead and transfers information in violation of a privacy policy or anything like that, you're not going to know about it. And even if a bad consequence comes from it, you're not going to be able to trace it back. The feedback cycle is just very, very hard. And when the FTC has looked at things like trying to implement the fair information practices, in the sort of online retail market, they got, notice and choice, and then got stuck on on the next line, which is access, right? The very idea that, you should be able to see as a consumer or as a what personal information does the company have about you. I mean, in my more sort of insane moments, I say, well, yeah, absolutely, that you should be able to see. You should be able to see where that information went. You should have a roadmap, a chart of what is the real history and provenance of any personal information that they have on you, just as a way of creating this kind of a feedback model. Because otherwise, millions of consumers simply have no idea what has happened to their information. And, presumably...
Neither do the companies themselves. No, they don't know what they don't know what the heck they're collecting or what their other divisions are doing. And it's not just a small company problem, it's also a really big company problem as well.
And they'll all get bit when, something does show up, and then they can't explain why it was they even did that.
But in advising on privacy practices, just like large international companies try to go for the most stringent standards of the countries that they're doing business in, I mean, usually counsel advise companies to go with the best practices, and best practices will change from year to year. And the only time you back away from best practices if, on a practical basis, they simply are not going to be able to perform for whatever they commit to in their privacy policy. Because obviously, if they state you're going to do it, the clear rule is that if you state you're going to do it, you will be liable if you fail to perform on what you represented that you would do. There's so many examples now of that. For example, think about large financial institutions. Large financial institutions shipping customer data, something they do every day. And there have been at least 5 different huge breaches of data tapes coming from one side of the company being sent by usual common carrier. Were these data tapes encrypted? Heck no. Is there a law anywhere that says that the data has to be encrypted when it's moved through a common carrier? No, there isn't. Should every institution have changed their practices the first time one of these data tape incidents hit? They should have. Why have they kept on happening? It takes them a long time to respond.
Okay, well, let me change the hypothetical slightly by positing a company that is much more mature and has grown to the size that they want to outsource some of their IT management. And of course, one of the benefits of living in the information age, supposedly, is that information doesn't need to be processed locally. It can be processed anywhere in the world because it can be sent anywhere electronically in the world. So if we assume a company that has a large amount of information and they want to outsource some of their IT processing to Bangalore, India, right now you're talking about sharing some of this information with a third party so that they can do some data processing operations on that information and send it back to you. What additional problems does working with a third-party information processor pose for your business and for data security and privacy?
Everything happened on the way to Mumbai. So it's a very real question, and it's going to continue to be a huge question, especially you get into issues about conflicts of law and jurisdictional issues very, very quickly. The easy answer here is you get the right vendor and you sign up to the right contractual obligations and nice, hopefully no ceiling on limitation of liability, but that's not the secret. I mean, we have wonderful, beautiful agreements. But the secret, particularly, and it varies where you're going to outsource to. So there's outsourcing to Milwaukee, and there's outsourcing to Mumbai. And there's outsourcing to Germany. So, for example, if you're going to Mumbai, they know as an economic kind of growth area that they're going to have to be very transparent. So the things that, and we do use outsourcing partners in Mumbai and other places in emerging economies, they will subject themselves to other balancing factors such as physical inspections. They will walk through an electronic monitor. They will not bring in telephones. They will not bring in laptops. We will use ultra-thin technology where the data actually never lives in Mumbai. It stays back at our servers. But it's a balance, I guess, is the long-winded answer here is where the economy and the legal prosecution, so there's, when there is a breach in an emerging economy, you may not have the police there to go after the perpetrator, and the data will indeed be gone unless you have segmented and prohibited data appropriately, particularly when you're doing development activity and you want to keep your IP segmented in addition to your PII. But it's a real balancing test, and I think the foolish would simply go on contractual obligation because that may dry up very, very quickly in the case of a large-scale breach. So you balance with other technological, people, process, training factors, and you think very carefully about how that data is transferred before it ever leaves your own servers.
Can I just add to that? Diligence and research going in, right? Because India isn't just one thing. It's companies with reputations for repeated, careful handling of data, and a whole bunch of other companies. So we like to advise that clients who are thinking of doing this, go and check out the company and find out what they're about, and call around and find out what their reputation is and see how they've done in the past.
Let me add one more to that, because in addition to the diligence, it's the post-ongoing diligence that's absolutely critical. Because as we've seen, whether it's Mumbai or Milwaukee, the data can equally be lost or misplaced or actually leave the premises through some much more malicious purposes. The current trend is to make sure that you have contracts that effectively bind it, but there's a couple of realities that need to be sort of thought through. One is that irrespective of who you outsource or where you outsource, the company still has the accountability for that data legally, and the company still has the PR hit. In other words, trust me, it's going to be Microsoft's brand name that gets eroded faster than the company in Milwaukee or Mumbai. So the approach that we take is, in addition to the contract languages, we require our vendors to actually attest to certain standards. And if they're handling any sensitive PII, whether it be things like credit cards or employees' information, they have to provide us with a third-party attestation that they meet those standards. So that's kind of an example of the way to do some ongoing monitoring.
Did you want to add anything, Maureen?
Oh, I'll just mention that in the financial services industry, this is an issue that gets the regulators very upset. And there's a very useful book on the risks of offshoring that the FDIC has up on its website. And, they list the things we've talked about in this very extensive risk assessment of the jurisdiction that you're going into, the company, their laws, their employee practices, their on-the-ground protections, how you're going to be able to continue to monitor and police it, how you're going to capture your information back, the fact that you need dual records, on and on. And a very big thing in the financial institutions world is that our U.S. examiners want the right to be able to go in there on the ground, just like they do for your domestic vendors, to examine your offshore vendors. And you have to get that in writing, and it's got to be enforceable. And there's a lot of tricks involved in making sure that's the case. And so all that work that goes into the offshoring contract on the front end and during, and then projections, of course, on how you're going to get out if you had to. What are your termination rights? What's the practical consequences if you decided to exercise a right to termination for actually being able to recapture total control of all your data without suffering breaches and thefts and everything else? And that's a very hard set of issues to have researched and make sure that you've got not just the paper promises, but technological and other solutions for getting it back.
The issue of breaches and thefts has come up here, and it's the second set of issues which I want to shift to now. We've been talking about sort of what can the company do with the information, and what policies the company should have in terms of voluntarily disclosing the information to third parties. But we also have the data security problem, right? How do you keep unauthorized third parties from accessing the information and using it in a way that's detrimental to the customer? So now we have a data security issue, and the question is, what can a company do at various stages of its levels of growth to try to keep unauthorized third parties from accessing this type of private information? Let's start with Michael.
Well, this is a really tough problem, and it's actually it's a problem that Bill Fenwick and I were thinking a lot about for our e-government paper too. And I actually don't have an answer to this, because it seems like as many rules as we put in place, we're always chasing security, and it's the classic, the bad guys get a step ahead, the security gets a step ahead. Mm-hmm. And I feel like this is, I don't know if we really have an opportunity to explore this here, but consumers and citizens are reasonably afraid that there really is no way to totally protect their information. I'll leave it at that.
In my neck of the woods, financial institutions are supposed to have written information security programs, both for themselves and for the third parties with whom they share confidential information under contract. And they're supposed to audit themselves and their third parties regularly. In California, all institutions that are collecting, not just financial institutions, all companies that are collecting confidential consumer information are supposed to also have security policies and procedures. And sort of the caveat to that is that if you're required to have such things, they should be in writing, and you should be auditing against them to make sure they're in fact in place. The stunning thing is, years later, since Gramm-Leach-Bliley was enacted and the safeguarding regs have come out, even in the most highly regulated industries, our written information security programs and our testing against them are still pretty darn weak. So we have a long way to go just on the basics, and including your vendor relationships and monitoring them. But good information security starts, kind of what the CPOs do, from the very start. Is that what sort of data are we going to collect and why? Why should we keep this data? How long should we keep it? Who's going to have access to it? What sort of technological procedures could help ensure that access is limited? What sort of personnel controls, both our employees ourselves and our contract workers and our vendors, could be put in place to restrict the access of the data? How long are we going to retain it, and then how long are we going to dispose of that? How far up on the curve are we with the FTC's guidance on appropriate disposal of customer information, which most companies right now haven't thought twice about that. So the whole realm in information security starts on looking at, the start of, what you're going to collect, and then its flow all the way through the company, all the way to the end when you put it to bed, and when you're disposing of it.
Maureen, do they do the audits that you do?
Financial institutions do the audits too, and they're examined by banks. However, big hole here is their vendors. In their contracts, they're supposed to have each of their vendors that have access to consumer information have written information security plans. And a lot of times, as Michelle suggests, they get that in paper, but there's no follow-through on making sure that these folks actually had a security plan, that it was effective, that the vendors are auditing against it, and goodness knows the supervisory agencies don't get around to doing on-site to all these vendors. And you'll see in a lot of these breaches that a lot of times that it isn't the first company, the primary company that has the breach, but it's a third party that you're dealing with. And as Peter suggests, the PR implications of that, hit the primary company over the head.
Your challenges for information security have actually got more complex as opposed to less complex. And it was interesting that I sort of was looking at the brochure about this event this morning that talked about, challenges with corporate databases. Well, this is the new corporate database. So data does not exist in databases these days. And you start to think about a single web page on your site, which actually is the ability to both collect and leak personal information. So in Microsoft's case, that's 12 million web pages. When you think about the way that information security has evolved, they've typically grown up in the protect the perimeter, put the sandbox around the network sides of things. Well, the network is amorphous right now. When we think about globalization, there is no boundaries to information. So it just means that thinking about risks around information security need to be much more than in fact, quite frankly, much more than a 360-degree view. You need to think about where your possible points of pain or threats are, and how are you going to mitigate it. I think it's also, quite correct to say that this is about risk mitigation, just the same as that walking across the street, there's a possibility that we're going to hit by a car. We take steps to mitigate it, but we can't possibly say that it will never happen. This is all about thinking about your risks and taking reasonable steps to make sure that it's correct.
But I think from a consumer standpoint, one of the things that's obvious from what people are saying is that this is an extremely hard problem. And so it seems to me, speaking again from sort of a public advocacy point of view, there are really two things that could conceivably be done. One is simply to minimize the amount of information that is at risk in the first place. Now, obviously, in an area like banking, banks are required to keep a lot of records. But in many of the other areas we've been talking about, companies have a very real choice about how much data to keep and whether to keep it in a personally identifiable form. The second issue, I think, is simply technological. When you do realize that there are so many points of vulnerability, you no longer can really think about only protecting a few or even several points that you think are weak. You have to think in terms of trying to protect everything at least some level, and by that I mean somehow integrating very, very easy to use encryption into virtually every kind of device you have. If there is some kind of integrated into operating systems, integrated into devices in such a way that users do not bear the burden of having to control keys, to have to remember passwords, where the encryption is in the phone, so the cell communications are automatically encrypted, or the link between your BlackBerry and Trio to the ISP is automatically encrypted, or et cetera, VPNs everywhere, then you are going to have some possibility of actually keeping information more secure. But it does have to be integrated in, I think, at a sort of device and OS kind of level before it's going to be a blanket sort of solution. And that's not going to be, it's not the end all and be all. There are obviously a lot of other things you're going to want to do. But it seems to me that that's where you would be going if you wanted to try to throw a blanket over this.
I'll definitely say yes, absolutely, and buy from Sun. Absolutely, that's what we sell. A lot of encryption devices, so thank you, Lee, for that. But there is a very real issue here, is as Lee suggests, it's key management and the administration of some of these techniques. And why didn't everyone run out and encrypt everything? It's tremendously expensive to do so. You know, I'm a shareholder at Sun. I'd love to see you do that, but that's not always appropriate for the type and character of every piece of information. Technology, I think, will have an increasing role in the overall security, but with the huge caveat that we do have to consider what is the character and the thing and the nature that we're protecting. It used to be, as Peter says, the perimeter control. You know, I used to, a little known fact, I actually was a 15-year-old CSO, Chief Security Officer at Mobile Oil. I was the part-time receptionist, and I had the key to the Wang room. So I had no viruses, no hack attack, 100% track record of excellence. I don't know, little known fact. It was very easy then, and you know what, the Wang box didn't do a lot. So the more we want our devices and we demand our devices to do a lot, the harder it is going to be to kind of take care of what is, I think, becoming an organic flow of data. So to the extent we're going to use tools like great OS systems like Solaris and encryption that's going to go down to the device level, that's going to be easy to administer for the end user, we also have to consider what is this information. And so the circle is now, instead of going to be drawn around the perimeter, is going to be around the data. And I think the structuring of data over time will get more and more granular, and as compute power rises and the facility of databases and bandwidth increases, you are going to be able to apply more of the technology techniques to the policy decisions. But I don't in any case believe that there will ever be a day where you just flip a switch and have a safe world by any means.
Well, we do have a long way to go in that direction, though. We opened up with the professor's suggestion that we think about Joe Schmo Internet Retailer. The Joe Schmo's Internet Retailer, at this point, will, when they open up a user account for you, they'll truncate your credit card number when you pop up to use it. But they don't have that credit card number, unfortunately, encrypted in their database on their back room. So, they're open to hack. So a lot of about what we could be doing to fix security breaches has to do with, as these things happen, getting more companies to roll out there and close the gaps. There's always going to be new holes, but we've got a long way to go on to some of the basic stuff.
That's absolutely right. And they should be buying a crypto accelerator switch.
There you go.
Okay. I do want to leave time for questions from the audience, but there's one more set of questions that I'd like to address to the panel, which is okay, in the unfortunate event that we have some breach of security, what notification has to be made? And I'm thinking of two hypothetical situations. One is your IT manager comes to you and says, we have reason to believe that there's been, unauthorized access to our internal data network. And, we don't know at this point whether any information was actually copied and outside of the system. But we have reason to believe that there was a hacker who was able to get past our firewall and was at least able to view this information in some way. The other one, of course, is the data tape that Maureen posited. We've been shipping a data tape from one location to the other. It didn't get there. We don't actually know what's happened to it. Right? It might have been, lost, damaged, destroyed, stolen. The shipping company, claims, it was logged in through their barcode, right? We know that the shipping company had it. We don't know where it is, right? But we're fairly sure we still got control over it. We don't have any reason to believe it's been stolen. Okay, but in either of those two situations, what obligations do you have to your customers to inform them about the breach, to try to minimize any consequences from the breach?
I have to tip my hat to Joan. You call Joan McNabb, and she'll tell you what to do. There's a very nice paper on the California website of exactly what to do with that situation and who to call and when to involve authorities. But the first thing that happens before you call anyone, obviously, is you do get the data. You talk to the IT manager and figure out what makes you believe that there was an authorized breach. How deep did it go? What data did they capture potentially? For the first one. I will hand it to the lawyers because they're the next people I call.
But, well, in the first scenario, if you have reason to believe that there was unauthorized access, it isn't just if you're a financial institution. It isn't just if you're in Jones, California state and have got that state statute. It's that 21 other states have adopted some sort of security breach law that largely is based on this standard, that if you have reason to believe unauthorized access occurred by a third party, that you should give the notice. And it doesn't require these statutes that you have to know that the information was actually used for wrong purposes. The idea here is to move in a pro-consumer format where you're giving the consumer the fair chance of at least being able to check their credit information and their financial accounts to see if any unauthorized transactions has occurred. And there's the statutory overlay. There was also, along with the California legislation, the FTC's best practices for industry. And although it's described as best practices, it's viewed very much as the national standard that should be deployed. Or you could face FTC action for negligence and deceptive behavior. There are several different versions of security breach bills up on Capitol Hill. Some of them are more akin to California's. Some of them are larger and would let a company try to assess if it's warranted under the circumstances and go through a lot of schmo. But for the most part, my clients think that their IT has discovered that there's been unauthorized access. I'm telling them they have to give the notice, and they need to give the notice promptly. On the data tape scenario, it's a little different. It's a little different because you're still trying to deal with the question is, has unauthorized access occurred? And what you need to clamp down on doing is clamp down on your common carrier and really push them as to, all right, where is the last known place where that data tape was? And they do that because I unfortunately have had these folks in my office a good part of the year this year. They can track back exactly where they last scanned that lovely little tape to what that facility is. And then you're going to hammer them to get in there and interview all the employees to see what you can find out about where it is. In one recent tape incident I did, there were 6 tapes being transported. 1 out of 6 wound up in the overgoods area, which meant that something had happened there at that site with these 6 tapes. And one was there, so what happened with the other 5? shards of one of the tapes was found under a machine. And the comic carrier went ahead and said, look, here's our written policies and procedures, here's the interviews of our employees, here's our practices. We think what happened is that these tapes got damaged in going through this shipping machine at this hub site. And per our orders that, that if they're damaged, they get thrown out. The one that wasn't damaged went into our overgoods area, and there it sat until we identified, which of our customers it belonged to. But did the client go with that and not give the notice? Because then you've got a reasonable belief to think that unauthorized access didn't occur, that, we kind of have a good sense of what happened to these things. No, they gave the notice anyway, and the reason they gave the notice is because by the time we did this investigation, both of those folks at the comic carrier and within the company themselves, lots of employees on either end knew about it, and they were afraid of a leak. And there's nothing worse than having a breach occur, not having disclosed it, and then having the public explain why you didn't. So there's law, and then there's practical concerns.
I just want to do a quick add-on to that, because I agree with all of that, and I think notifying is an excellent way to get in front of that PR thing that could happen to you. But the other thing to remember, too, is to notify the correct law enforcement people as quickly as possible, too. So everyone's got a local branch of their Secret Service. They have technology guys that can come in, preserve the forensics. So if it, not in the case of the lost tapes, but in the case of a potential unauthorized breach, we want someone very quickly to be able to actually get the bad guys, if possible, and prosecute them. There have been documented cases where the U.S. District Attorney here in San Francisco actually has met the bad guys at the airport on their way to some jurisdiction where there is no extradition. So it's very important not just to think about your customers. They're crucial, obviously. Think about the employee potential for leaping stuff that you may not notify. That's very real. But also preserve the crime scene as much as possible so that you can actually do something about the breach.
And just one point, other point, which is that this is not a problem of corporate America. This is very much a problem that affects government entities as well. I mean, the genesis of the California bill was a breach of the California State Data Center, which put state employees at risk. And just earlier last year, we had an incident where an entire branch of one DMV out in Nevada was basically busted into, where the government had outsourced some of the operations with DMV information to a private company, believing that the information was being kept encrypted by the contractor, when in fact it was not. So, the state DMV director simply did not know, or somebody did not know what it was that they were supposed to be doing.
So something that has been passed around here a lot, and without really zeroing in on it, is this reasonable belief standard. And the standard was built into the hypo, right? And so, in case you don't know, that's the standard in the California and New York statutes for when you have to have some sort of notification. And what the reasonable belief is that some PII essentially, or specific PII in various combinations, there's been a breach with that sort of information. Now, what you see a lot is less sexy, and that is that there's been a breach and some corporate information's been exposed. And then really the approach is an inter-corporate relationship issue where you also have to do careful Tylenol type getting ahead of the problem. But usually it involves doing a root cause analysis, figuring out what really went wrong and why the breach happened, fixing it so that it won't happen again, and then carefully working with your customers so that they understand how important this issue is, and so that they can really understand why they're not at risk of repeated incidents.
And I can tie the lost data tape back in with the first panel by suggesting what we need is an RFID chip in the data tape so that we can locate it when it gets lost. I do have one more question for Lee, but I'm going to put it aside for the moment because I do want to leave time for questions from the audience. Because we have a wealth of expertise up here, experts in privacy, compliance, and data security. So I want to ask the audience, well, what questions do you and your clients have? And what questions would you like the panel to answer for you? So our first question is back here in the back, and the microphone is making its way back to you.
Hi, I work in the private sector. On the topic of global data transfer, what is the fundamental difference in defining what an agent is versus a vendor, third-party vendor? So if you're outsourcing to a company who's providing services and acting on your behalf to provide services, whether it be to your employees or to your customers, versus outsourcing to a third party that you're selling the data to that potentially might sell other goods and services. Is there a fundamental difference between the two?
The way I think about it in your first example, where the company is performing services on your behalf and is bound by what they can and cannot do with that data, whether it's a vendor, an agent, or somewhat synonymous words. The second, my back goes up when we hear the word sell data. That's an entirely different transaction. That's a customer.
Question up here, Nikki. You got a microphone. This room has a lot of space.
You used a phrase when at the very first, the very start of the panel, a with relationship, and I think you were using it in talking about, say, for instance, buying a book on Amazon.com, where Amazon is building a relationship with the person, or a bank is building, I think it was a bank, is building a relationship with the person. Can you help me understand how you couldn't apply that same description to Google, for instance, if you're trying to restrict them from maintaining data about customers? Because coming from a marketing background, it would seem to me that Google itself is trying to build a relationship with the person so that in the future they're only seeing ads for products that they might be interested in, or they're only getting streams of information on searches that they might be interested in to improve or speed up the process of finding their information.
Well, I actually was using that term in a different way, but and let me explain what I meant by it. What I meant by it was in terms of contrasting something where the company essentially has knowledge about a relationship it has with you versus knowledge that it obtains about relationships you have with other people. It's actually a term I borrowed from the sociologist Irving Goffman, who talks about the informing character of the with relationship when he discusses the sociology of conversations and dyads and other kinds of sort of group interactions. So my point was that if it's about a one-on-one between you and the company, that's different from when the company is actually in a position to see that you are talking to Maureen, or Maureen is talking to someone else, et cetera, or sharing things. And so that's the language I was using. But the point, nevertheless, is well taken. Certainly Google can seek to develop a customer relationship with an individual, just as any other retailer does. And in fact, Google does do that, but again, Google has developed a sort of a relatively, I guess I would say, privacy-sensitive policy in the sense that it is compartmentalized. Google learns the most about you if you have an account with Google, some kind of an account. So if you have a Gmail account, then you will have a Google account, and there will be information that is acquired about you through a cookie that reports to Google.com. And if you have some other account with Google because of one of Google's other services, you will again have a relationship within that context. It is not necessarily the case that the relationship you develop with Google through, say, a Gmail account. It's the same it would be if you had some other kind of service to Google. There is, of course, a choice as to whether they want to have a sort of a unifying situation where any service with Google essentially integrates the data about it, or whether they want to have it more siloed. And then when in the sort of the zero level, which is where I am just going to the Google site, which is meaning I do not have any kind of Gmail account, and I am going to the Google site. Now, I think from the perspective of Google as a company, I have not chosen to enter into the kind of relationship that I could were I to have a Gmail account, or to use Yahoo as a different example. If I were to have a Yahoo email or a My Yahoo, et cetera, all of these are different levels. But what I was simply saying is that there is this zero baseline level where there is the minimum level of relationship possible, and in that context, I would urge their policy should be not to retain the individual personally identifiable data, or data from which my identity can be inferred with other information such as IP host number, et cetera, et cetera.
Other questions from the audience? Professor Ramasastri? Did I get that right?
A question for Maureen. You were talking about financial institutions and the audits and the vendors, and just a question about the card systems breach. Is that a situation where card systems really didn't have the proper systems and controls in place? Yeah. And a related question, was there a recent, in the litigation that's going on, was there a decision that the notification did not have to be made, and I wasn't sure by which party? Okay.
No, Card Systems was a payments processing vendor that the major credit card companies, Visa and MasterCard, used. And the type of breach, because there's all different types of breach, some of them are from hacking by third parties, some of them by employee wrongdoing, some of them by oops situations like the lost laptop or the BlackBerry, some of them are in transit, the lost tape, or the box fell off the back of the truck, that sort of thing. But this was the sort of breach that was a third-party hacking, and it was clear that it was a security firewalls, inadequate protection of the databases from external resources sort of breach. And so clearly somebody was going to have to give the notice. So then who is it going to be? Well, MasterCard and Visa took the position that the individuals, the entities that had to give the notice were going to be the ones that had the closest relationship with the customer. And that is not MasterCard and Visa were processing all this credit card information, payment stuff, through the system, but instead the banks that were at the back end that weren't aware that MasterCard and Visa used Card Systems as their vendor or what they did there, and had no auditing or monitoring abilities or rights over Card Systems. So the banks had to give the notices to all their customers, and moreover, they had to pay for the issuance of the new credit cards or the new debit cards that had to be done very promptly under a new account number. And they had to field all those ugly customer phone calls saying, what do you mean I have a new debit card number? I have electronic bill payment, and now I have to call my 15 different service providers, and they're going to say I didn't pay, or my check bounced, or whatever. So they fielded it. So there's a couple different levels of lawsuits going on now. And Card Systems is financially not going to survive this. They've already sold off the valuable part of their assets to another entity. They're going to be sued by MasterCard and Visa, and they're already being sued by groups of financial institutions, and they're being sued by consumers. So it's a bad situation. But you compare that with a situation like ChoicePoint, and there's going to be all sorts of good suits going on with ChoicePoint. Very different sort of breach. This was a breach where ChoicePoint failed to adequately do a background check or a clearance process over the people for whom they were charging fees to have access to their super-duper confidential database about all these folks in the country. And their clients, of course, have run the gamut of lots of government agencies. In fact, I think that's their primary source of revenues, but all sorts of other third parties. And it turned out some of the third parties that they were allowing to have access to this data, they hadn't checked enough to, quote-unquote, know your customer. And we'll talk about transparency maybe in a minute, but to know your customer, to know who these folks were that they were allowing this personal stuff to have access to. And the sorts of suits that they're facing now, a lot of them are attorney general suits. where attorney generals are coming under state law saying this is an unfair and deceptive business practices, and we're going to get punitive damages from you for being so shoddy in the way you operated your business. And there may be individuals as well that bring suits. There may be different users of the database, people that have contributed data to ChoicePoint that have a beef about their information not being shared with others. But two very different sort of breach situations of what caused the breach, and then who's impacted, and then who's up in arms about it. And just a note on transparency, because we've heard both from our luncheon speaker and from Lee talk about, well, we need to have transparency on what information is being collected. Well, in my neck of the woods, that sends chills up my spine, because what you're really saying is you want transparency for consumer rights to know what information is being collected about them and the companies they're doing business in. But the other big T word out there is transparency that the government is requiring companies to have in entities they're doing business with. And the biggest form of this is the requirements under the USA Patriot Act and the Bank Secrecy Act for banks to use, quote-unquote, enhanced due diligence to truly know who they're doing business with and who those folks are doing business with and who they're owned by, and report all of that in databases that if they perceive a pattern that they think may be suspicious, gets filed on highly confidential reports called suspicious activity reports. So the T word is used a lot, in privacy circles, and it has very different consequences. Some makes information more being collected that's kept more secret, and some of it is the idea that, like the Fair Credit Reporting Act standards, that information about you might have access to as a consumer to have more freedom of information.
We're almost out of time, and I did want to ask one more question of Lee, and I only thought of it when I was sitting up here. I would have given you a chance to think about it in advance, so I hope I'm not catching up to you. But I guess the question would be sort of as a going away present for us. What are the one or two, consumers come to EFF to complain about corporate privacy practices. What are the one or two things that corporations are doing that really tick customers off? What are the things that really that customers really dislike and come to you to complain that corporations are doing?
That's actually a very hard question to answer, because it really runs the gamut, because there are a lot of different things they complain about. I guess from a pure volume aspect, people complain most about spam. I mean, frankly, it is intrusive communications that they complain about the most. And of course, based on what we've heard today, shouldn't that obviously be the case? Because no one can know about the intrusions or violations of privacy that we complain about, but which occur behind the scenes. What they see is the end that hits them, which is, gee, someone sent me an email about something and I didn't want it, or how did this company get information about me? So, that's the first thing. The other sort of general category is people complain generally about what corporations are doing with their, in terms of their Social Security numbers. So I give a lot of talks where I complain about privacy and beat up on both corporations and the government. And most of the time, people are not interested in very much of what I say, except that I can't believe that they are treating my Social Security number or some other common piece of index information in a very, very cavalier sort of way, such as, well, you get some kind of a mailing from, I guess it's Sally Mae or someone like that, where, right, on the envelope, it's your Social Security number, and
but it's surrounded by other numbers on either side.
well, yeah, and when I think what was it that happened is there's California passed a law saying you couldn't have that, so they substituted zeros instead of hyphens. And then they kept doing it. And at some point, there's a certain degree of, in many ways, it's not a specific complaint, there's an attitude of arrogance and intransigence where consumers perceive that companies do not care, and therefore they will act. And so any little thing that they see as an evidence that they do not care about consumer privacy just sort of ends up ramping up.
Okay, well, with that, we're out of time. We're going to take a 10-minute break, but I want to thank our panelists for